Thank you. Good afternoon, all of you. I think I'm going to play the role of the boring lawyer on this panel. And a lot of the things that I want to talk about with this theme are to do with the nature of a particular kind of law, that is criminal law, which is what I work on. And I can understand that apart from a couple of lawyers that I can identify in the audience, I might lose all of you. So please, if that happens, then let me know by yawning or any other form of protest also that you may have. Right, so let me begin now. So what I want to really talk about is interrogate this idea of criminal law being being or, or playing a gatekeeping role to democratic rights, and how we are seeing that happen more and more often in today's political context. But it is by no means something that's recent. So the first thing that we need to acknowledge about law is that whether we like it or not, but law does play in society or in most societies a function that is double-faced. It's a Janus-faced function. And the more important one really is that it sets narratives or norms in place. That legal rules also are talking about not what just exists, but what the law imagines to exist in society or imagines that should exist in society. So it has a double function there. It talks about regulation of what is and also regulates what aspirations are acceptable or what aspirations are recognized or achievable as well, right? And specifically, we see that in criminal law, this happens with three aspects. And I want to really look at how it interacts with sexuality and trans issues as well. We see that criminal law creates this gatekeeping function around three very critical aspects in society. These are what I call very unceremoniously and very inelegantly the gatekeeping around publics of society, the bodies in society, and relations in society. So we are talking about three. There could be more. This is by no means supposed to be exhaustive, but criminal law plays an important role in regulating what is the public of this society and who has access to the public of society, right? So the first thing, let's say, which connects to a long-standing trans issue has been take a law, which is a criminal law, which prohibits vagrancy or beggary, right, as it is called, which very critically locates this regulation as to who the public spaces, physical spaces in a city or in a town belong to. How do you manifest yourself in a public? And it says that certain people cannot manifest what they want to do in the public. If they do it, they are asking for criminal regulation. Or the criminal law makes those public spaces inaccessible to certain identities, certain forms of behavior, right? It also interconnectedly says you cannot perform certain roles in public spaces. So for example, with regard to colonial and even post-colonial regulation of certain traditional, let's say, professions, right? We have a very clear criminal regulation that something counts as vagrancy, something counts as criminal nuisance, and something else does not. And there is a politics of what is an acceptable profession and a non-acceptable profession there. The second gatekeeping function, which we see very clearly, and I don't really need to go too much into it, is the gatekeeping over bodies, right? And of course, we all have seen the long shadow of Section 377, which was most specifically regulating bodies and bodily conduct. We are seeing repercussions of the same thought process or the same belief. So you have, of course, now something which regulates reproduction, right? And access to ART, the technologies of reproduction. You also have, and this is an interesting aspect as well, what bodies are not regulated by the benign function of criminal law. So where do you ask for protection? The law of rape, for example, right? Who it excludes, who it includes in its standard definitions, etc. Again, gatekeeping the idea of what can be done to a body, what the body can be used for, what the body can produce, etc., etc., right? Sex work is another example as well. And finally, you have the gatekeeping of relations between people. So you could talk about the structure of family law, the ensuring that family law has a bite to it by always reading it together with criminal law makes it a criminal law issue as well. So things such as maintenance are very often in magistrate courts criminal law issues, right? So who is entitled to all of this? So we see a paradox here. And the paradox is that in criminal law, and I hope I've not lost all of you together already, the paradox is a simultaneous invisibility and a hyper visibility that the law confers. I'm not the first person to say this, work has been done on this in the past as well. But what you essentially see is a hyper visibility on aspects of law that criminalize, that impose liability. There you are the chosen target. Your form of expression is the chosen expression which will lead to liability. But where it comes to protection of the law, right, then you are invisible, right? So you don't get protection under the normal criminal law structures that are otherwise available to others. The law of rape is a good example of this. You get a very watered down acceptance or visibility much later. So you have something called abuse in the Transgender Act, but you know that that's not rape, and therefore you don't know where your protection is. The law is unclear, right? Invisibilization can happen much more clearly, which is of course that something like the ART bill will say that you just are disentitled for some kinds of procedures, right? Otherwise available, right? We can, let's say, further the example a bit. So you see a visibility in terms of a NALSA judgment and a simultaneous invisibility in its enforcement in statutory law, right? So there again you see this dichotomy. It's as if where you are a right-holding citizen, the law treats you as invisible, but where you're a citizen who can be governed and potentially put in jail, you are very visible, right? Let's take another example, the NRC, right? So the NRC and trans issues with the NRC of documentation and the impossibility of documentation, invisible, even to the law most clearly, and also sometimes in public discourse, right? But it's right there. So where again a potential liability or a loss of statehood can happen, you are invisible to the law here, right? Now, so if we look at this entire structure, and I'll not take too much time, what you see is in this entire governance module through the law, we started with this idea that law creates norms. And law in society also feeds into this idea of what is acceptable, what is non-acceptable, what is imagined and what is unimagined. It becomes impossible, therefore, to look at certain communities, trans communities, and imagine them as full citizens of the law, as full subjects of the law. Because the law is constantly playing this game where on a question of what rights are to be conferred, you are not imaginable at all. But on a question of what liabilities are to be imposed, you're the usual suspect in that sense, right? In criminal law, this becomes even more interesting because you also see a particular aspect of punitiveness that is attached to criminal law. And criminal law has for long been content with excluding you either directly or criminalizing you directly, right? But now in a right where everyone is forced to adopt a rights-based language at least, a new phenomenon can be seen to be developing, which is criminal law that is punitive by implication, right? It does not target you specifically in a sense that it does not say something about you, but by implication what happens is that you are targeted. And this, I want to connect this to this idea of democracy or a demand of democratic rights, etc. If you see modern criminal law in this country today, what is essentially happening is that from a non-subject, if you demand to be treated as a subject, criminal law is the gatekeeper to that as well. It punishes that. So if you go protest the NRC, if you go protest the CAA, there is the criminal law that will take care of you, right? The demand itself can substantively be valid. The government will never accept that it is depriving people of citizenship, but it will ensure that by implication citizenship cannot be secured. And this is a function that is made possible through the criminal law only. It is the criminal law here that is serving as a barrier to you exercising a kind of democratic right. Let's call it the right to protest if you want to call it something. But I would say this right of being itself, right? Which the criminal law says that you can't ask for. And if you ask for it, then deal with the entire heavy hand of the state, and then let's see what rights have to be given to you. All in all, again, to go back to this dichotomy and this double-facedness, in theory, granting you everything that you are asking for. So in theory, the government has protected transgender people because it has passed an act, right? Simultaneously doing this as well. I had one more point, after which I will stop. So it connects, and this is my last one, sorry. It connects to this idea of a citizenship by design is what I would like to call it, where you're seeing that our society and our legal system is deliberately shifting to this punitive mechanism. Our discourse today around crime is around punitiveness. We want to know how better we can punish, how more we can punish, how we can punish so that they don't commit a crime again, etc., etc. And in this idea of increasing punitive behavior of the law, it is fundamentally incompatible with an inconvenient demand that might be made by certain citizens or might be made by certain people. Also added to this is that this punitiveness is connected to the fact that, again, to look at the law as a norm creating and a norm following institution is created to the idea of who is it that punitiveness is meant to protect, who is it that punitiveness is meant to punish. And very clearly, if you fall within a certain structure of identity, then you are entitled to the protection of law. And if you fall outside it, then law serves as that gatekeeper which does not let you in. Last thing is that the idea of the gatekeeper is not mine. This was said by Camus, actually, of looking at law and the institutions of law as gatekeepers that entitle or disentitle you to certain things. With that, I'll stop.